to give them the
their
2 to 10
entire
off.
2% shift off, correct?
Any questions from Commonwealth?
No questions.
Overtime, Article 18 proposal, very simple. We are proposing to delete paid leaves for the purposes of computing overtime, and all those leaves referenced there. You can see that over a 4-year contract would be a cost savings of $5.3 million.
Association, any questions? No questions. Donald? Commonwealth?
No questions.
Good.
Union Business League.
Okay.
Let me read the slide. The current language of Article 15, Section 3 states, association officials or elected delegates shall be granted, subject to management's responsibility to maintain efficient operations, up to 6 weeks of leave without pay each year without loss of seniority credit where such time is necessary to enable them to attend official association meetings or conferences. When we go to the next slide, this is the list that's referenced in Article 15, Section 3. Okay? What we're asking for in this proposal, those are the, let's just, 19 is the list of those in Article 15, Section 3. Turn to the next slide. These are all the following different types of state committees that the PSUA has under number 1 of the previous slide. Therefore, our proposal is that what we're asking for is, well, let me back up. Slide 20, all of those different state committees, they're not identified in the contract. The only thing that's identified in the contract is PSUA state committee meetings, okay? In addition to that, number 4, president's meeting. There are no specifics in the contract with regard to the limitations, if there are any, with regard to those 2 Union Business League requests. We don't know what different state committees that the PSUA has, how often they meet, how frequently they meet, and what duration. For the president's meeting, the same thing. We don't know how many people are entitled to go to a president's meeting. There's no specifics provided under those. I'm not here to say that the union has abused these. All we're asking for is that the union provide us some specifics with regard to their intent on using those committees throughout the course of the year. Duration, number of occurrences, number of employees. In addition to that, what we want to do is memorialize a practice that the PSUA and the Commonwealth has had for granting a Union Business League Day to members to attend what's called the pre-meet day for our grievance process. We have area committees both in the east and the west. Each committee is held monthly. It's either a 1 or a 2-day committee. Both parties have what's called a pre-meet day. Before the committee actually occurs, they hold a pre-meeting to review those grievances that are going to be heard in front of the committee. Since the early 2000s, we have provided the local union people coming to the committee the day before the committee leave without pay with seniority credit. Okay? It's not covered under Article 15, Section 3. We've mutually recognized it through the process of new union leadership. It's no dispute. All we want to do is memorialize it in the contract so it's very clear and there's no disputes whether it's provided for or not in the future.
May I make a suggestion, Mr. Chairman? This sounds like one similar to when the union made its presentation on process for heart and lung, that there does not seem to be a substantive dispute between the 2 sides. Am I correct with that?
Yes.
What I would ask, the panel begins its deliberations June 9th. Perhaps if you and the union president could just talk before then to see if you want something contained in the award on this, we need guidance. We might do something that really screws it up, like some of those arbitrators you're talking about. But I would ask if you and Roy perhaps could meet ahead of time and perhaps put some parameters around it that might give us some guidance. If you can't, you can't, but I would ask that you try.
Yeah, Fred's actually stole my thunder there, because I was going to say the same exact thing. And you can't throw this on the panel and say, define what's a president's meeting, or define what a state committee meeting is, especially if there may not be disagreement, because apparently on your list on 20, you've been granting leave for those occasions. So if you want specificity in the contract, that's not a problem, but don't ask us to decide which which meetings qualify. So you all get together on that, and then by June 9th, if you're having a disagreement about one or two, fine, we'll resolve that. But I think you can probably work that out.
Fair enough. Thank you. The next issue that we'd like to address is actually the union's proposal regarding union business leave. And the union proposes to provide that all periods of union business leave be considered time worked for all purposes. And I believe in their presentation, they presented this as the Commonwealth would pay an employee for union business leave, and the union would reimburse them. And what that would do, in their opinion, would provide the employee with credit, paid credit towards their retirement earnings. And I believe this objection was made, or it was noted at the time. I just want to stress that the State Employee Retirement Code is the authority to determine what leave is designated as retirement covered earnings, and that it's not within the jurisdiction of this panel to decide that. And in fact, this union's well aware of that, because they've gone to the legislature and had the SERS code amended to include additional members of the union who are on full-time leave to be paid by the Commonwealth and reimbursed by the union. And they went through the legislature and had the code amended to cover not only their elected officials, but their, I think, up to 14 business agents.
Okay. I know we had a discussion of that during the union proposal, so we'll appreciate your comments on that. We don't have to discuss that.
Brian, great. On seniority, the contract has various types of seniority. There's bargaining seniority, classification seniority, seniority obtained at the work site. Management's responsible for maintaining those lists. Recently, there's been some disputes about the lists, if they're correct or not, and some of the locals have developed their own types of seniority where they've combined different groups of time into classification seniority. So the Commonwealth proposes that we reduce it to one type of seniority, bargaining seniority, and delete all the references to classification and on-site seniority. Additionally, we would propose as a housekeeping measure to modify the contract language to conform with a court case called the Jenkins case, which went through, I believe, the Supreme Court. The contract says that if you leave the bargaining unit, you lose all your seniority. And in a nutshell, the end result of that court case was that you do lose the seniority, but you retain it for purposes of promotion and furlough, because that's covered under the State Civil Service Act. So we would propose to just clarify that as a housekeeping measure.
Ty, last point. Is that if you leave and return? Is that
correct? I believe it's provided you stay within the classified service.
Question?
Sure. I just wanted to clarify. You're at least in this particular proposal, you're proposing that there's one type of seniority, bargaining unit seniority, correct?
Correct.
But this is in contrast to the vacation proposal that was made. In regard to the vacation proposal, you're asking the panel to bid vacation based upon a classification bargaining unit seniority.
No, that's not correct.
Okay.
The vacation selection is by bargaining seniority, but we're saying to carve it out within the classification, not classification seniority.
But that's the same as this.
No. Bargaining, we're proposing in the vacation selection using bargaining seniority, which is what the contract language currently says. But we're saying to select within your classification.
All right. So you think that's the same as this then?
No.
Okay. I just wanted to clarify.
It's the same seniority. There's one seniority, bargaining unit seniority. So with regard to the vacation selection, if you take all of the correction officer ones that work the 6 to 2 shift, and they're bidding for a vacation slot on the 6 to 2 shift, they're using their H-1 bargaining unit seniority against other correctional officer ones. So let's say I entered the bargaining unit as a tradesman, okay? In another classification, I spent 5 years in the bargaining unit in a different classification, and then I went into the correctional officer position for 5 years. I now have 10 years of bargaining unit seniority. When I'm selecting vacation as a correctional officer 1, I'm using 10 years of H-1 bargaining unit seniority to select against other correctional officer 1s, not food service instructors, canteen clerks.
But you're proposing to delete all references to classification. So how do you delete all references to classification?
Classification seniority. The contract refers to bargaining unit seniority, classification seniority, on-site seniority. There's all these multiple seniorities within the contract. All we're asking is let's make it one.
But vacation you're proposing is bid based on classification seniority.
No,
here's
bargaining
that
unit seniority within classification. There's a difference. You had a gentleman testify, who was a tradesman, who I think had been a CO1, he was sitting right there in the second row. He carries his CO1 seniority into his trades classification for purposes of bidding vacation.
So it's just the way that you word it, is that what you're, I mean, that's what it seems to me, because if my bargaining unit rights are based upon my bargaining unit seniority, it shouldn't matter on the vacation bid whether I'm a tradesman or whether I'm a CO or whether I'm
No, with our proposal, we're saying it does matter.
So for vacation, you want it one way, but for everything else, you want it
No,
another.
no.
It's just not getting it.
No, take it.
No, I get it, Freddie, I do.
No, take it this way so we understand it. You know, use this as an example. Somebody's hired July 1st of 2000, and that's their bargaining unit seniority date. Then they change classifications July 1st, 2005. That becomes whatever classification they change to. July 1st, 2005 is now that their classification date for that classification. So what you're saying is you want to delete that there won't be such a thing, and they started SCI Dallas on July 1st, 2007, and that becomes their on-site seniority date. You want to eliminate the references to the classification and the on-site. Always use the bargaining unit seniority date. And in terms of vacation, you'll still use that July 1st, 2000 seniority date, but you'll just be bidding among food service instructors or bidding among CO1s.
Correct.
Whatever. Okay, I understand.
Thank you, everybody.
All right. Any further questions?
No further questions.
The department has a reasonable suspicion drug and alcohol testing program, and it's outlined in Appendix H of the contract. In that appendix, it lists the specific drugs that are tested for. We propose to amend it to be consistent with the Department of Health and Human Services list. Recently, there were 2 drugs added to that list under the federal program that are not on our list currently. One is ecstasy, the other is a drug called 6 AM. So we propose to add those to the list.
I have no idea what 6 a.m.
That was 4 hours ago.
I don't know, but it sounds interesting. I think the panel ought to try it and let us know.
Ty and Brian, I'm going to ask on this one too. When you're talking to the union officials about the leave time, why don't you discuss this one as well? It doesn't sound to me like this would be one that there'd be a dispute, but it certainly, part of the frustration I have is that there have been no negotiations leading to this, and a lot of the stuff could have been done in those negotiations. So I doubt you'll have a dispute here, so if you could include that in your discussions.
Is that the only change, Ty, in the list of drugs to be tested?
Those are the only 2 to add, correct. We're going to retain the list as it is and add those.
And just add those 2?
Correct.
And I think if you just made the reference to the DHH, the Health and Human Services list, then if there was an amendment to the Health and Human Services list, you would just follow that.
Correct.
That's what I'm talking about.
Next proposal is on classification grievance process. What we're proposing here is to expedite the classification grievance process to eliminate the first step and then provide